My name's David Favre. I've been part of the animal movement in the United States for 40 years. When I went to college, there was no environmental law, let alone animal law. And so I've had the opportunity over my life to see an extraordinary explosion of interest and focus in these two major areas. And it's often, when I talk to people, they get very frustrated about how hard it is to get change to happen for animals. And I can just sort of suggest to you, amazing things are happening for animals. It just does take some time. I also have the obligation to apologize to everybody in Canada for having elected President Trump. I want to get that out of the way. When I travel internationally, people look at me and say, what happened? How did that, I don't know. I'd also suggest to you that I think you won the NAFTA debate. Milk subsidies are still in place, and I think Canada came out just fine in that debacle. This conference, I'm very pleased to see the focus of the conference and the list of discussion points that are to be done over this day and tomorrow. I think are fascinating and worthy of tremendous attention. And again, a sign of this conference couldn't have happened 10 years ago. The people weren't here, the ideas weren't here, the books weren't here yet. There's so many things that are going on. Now, I started with my first law review article dealing with animals back in 1978. And as a result of that, I got invited to the first national conference that dealt with animal law. It was a gathering in New York City of everybody who had shown any particular interest in any particular animal issue, and there were 25 of us in the room. That was it, whole country. A year after that, we formed an organization called Attorneys for Animal Rights. The next 5 or 6 years, we found out that didn't produce much fundraising as a nonprofit because people don't like to give money to attorneys, and animal rights clearly was not on anybody else's agenda in the 1980s. So we changed our name to the Animal Legal Defense Fund, and I was a board member of that for some 22 years. I chose to focus on animal law in law school, and one of the projects that we've been able to do at my law school is to create an animal center, animallaw.info, which has a comprehensive set of materials, 6,000 files of all the laws in the United States and discussions of the laws and cases that relate to them. I also happen to have a fair selection, but I wouldn't say it's comprehensive, of Canadian law on the website as well, and we just put up one on Britain. So that sort of things are available. And my one advertisement is I had a book that just came out in July, which sets out, I think, a fairly comprehensive paradigm for how to think about animals in an ethical context. This represents about a decade of trying to figure out how I wanted to say things. So I suggest that to you, because this presentation is not about creating an animal context, ethical context per se. Instead, I want to deal with the intersection between ethics and law itself. We're going to take a simple proposition, which I assume everybody in this room would agree, and see what happens when you put it through the meat grinder called the writing and drafting of laws. This is not an animal rights presentation. That's another whole presentation. Okay, so if you want to talk about animal rights during the question period afterwards, we might be able to do some of that. My proposition is that one should not beat their animals. Okay? That's an ethical position. That's one of my animals, and clearly when he looks at you like that, you couldn't possibly beat the dog, right? But I'll give you a short story. Back in the 90s, Steve Wise, who's a fairly good friend of mine and on the board of the Animal Legal Defense Fund before he went out and started doing all this good primate lawsuits in New York, were working together, and Peter Singer, the philosopher, contacted us and offered to us that he's putting together a book on animal issues and would like Steve and I to talk about chimpanzees and the law. Great. So Steve and I get to work, develop a chapter, send it to him, we go through a little bit of editing, and then all of a sudden we get a letter back from Peter Singer saying, I'm sorry, we can't accept your chapter. It's not radical enough. It's too full of compromise. It sounds squishy. You're not being absolute in your position on what to do for chimpanzees in the law. And that was it. So we're not in the book. And this is the difference between lawyers and philosophers. Peter Singer's in a position to say absolutely what he wants with absolute clarity, and he doesn't care about what anybody else says. He doesn't have to make anybody else agree with him. They either do or they don't. Law is a whole different process, right? Ethics is personal. Law is social. You have to have agreement among others to have a law come into play. That means, in our world, you have to compromise, right? And in fact, the stronger your position, the more likely you are going to have to compromise. Because other people don't hold that position. So that's what we want to see as we go through this. And I don't know how many of you had the opportunity to talk to a legislator about an animal issue. It's an eye-opener. If you haven't, I suggest you try to put yourself in a position to have that experience, just so you understand how difficult this whole thing is. And when you go to talk to a legislator, what are you going to see? Well, here's a few of the responses. It's about dogs. Who cares? You can't do that, it's not enforceable. What is a beating? Maybe the dog deserved it, so we shouldn't say anything. And what about cats and birds? If you're going to say you can't beat dogs, aren't you going to say you can't beat cats and birds? Or horses, or possums, or raccoons, or slippery slope problems. So you have people who have immediate responses. And part of the problem about legal adoption is considering, well, who do I have to convince to get a law passed? Well, it's pretty obvious, right? You've got to convince the legislators how to get that. And almost none of them got elected to their position of political power because of animal concerns or policies. That's almost always a secondary, tertiary sort of concern that they might have. You do run into some who have very strong feelings. I worked with one congressman who came to the animal issues because his 22-year-old daughter told him to. And it sort of woke him up, and he said, okay, let's see if we can do something. So as we got through that process, he then got unelected the next time around, and so I lost all that work that I've done, good work with him. Is there a consensus about if we should not beat our animals? Well, I think there's a pretty, I wouldn't be embarrassed to go to a elected politician and say, we should have a law against the beating of animals. Right? Because the word beating it has inherent in it a negative consequence, right? That's not perceived as a good thing. Beatings are inherently negative in nature. And so you could at least have that conversation. And then you get deeper into what that might or might not mean. The other thing is that sometimes non-lawyers get mad at us lawyers because we sound picky. And that arises out of 3 years of education where we professors drum into their heads how important specific words are, and that you must understand what that word means in the context of how it is being presented. In the art of drafting the law, there's 2 points. There's how do you get the law into place, and then how do you implement the law. And the getting the law into place process is the one most of you aren't particularly familiar with. And while you would think that we would want absolute clarity in the law in the drafting process, what you find out is that the compromise process necessary to get laws passed requires you to use sometimes squishy words, because that's the compromise. You use a word that can mean different things to different people, and therefore they can all agree to it, even though subjectively they don't agree. Many a law has been passed on that. too fast. For example, is it illegal to punish your child? No. Is it illegal to beat your child? Yeah. Well, that depends. What does the word beat mean? Spanking on the bottom of a 2-year-old that has a diaper? Is that a beating of a child? I don't think we'd say that. Getting the whip out on the bare bottom of a 10-year-old? Yeah, that would probably do it. Now, what do we think about that? With children and with animals, there's a continuum of possibilities of human conduct. And the difficulty is deciding where on the continuum to draw a line. The other thing is that we must recognize that the law doesn't seek to set out best possible conduct. It seeks out the least acceptable conduct. It's a minimum. That you shall not beat your dog doesn't tell you the positive things you ought to do with your dog. This is a problem when I go to veterinary schools and I have to talk about veterinary malpractice. In other words, that legal standard by which they could be held liable for doing bad things. And I have to explain to them that when they're in school, they always talk about best practices. That's what is the A student doing, the best possible things to do, and everybody ought to aspire to this. They don't ever talk about or think about what is the minimum acceptable conditions. And malpractice is when you do something less than minimal acceptable. And that's hard. But then I really scare them because I tell them, as a lawyer, I have no idea what that is, where that line is. And in fact, you, as veterinarians, have to tell us, as lawyers, what is the minimally acceptable practice. So how are we going to do this? We're talking about creating a crime. This is a non-trivial act, right? Because you may take away a human's freedom. You may take away their money for a violation of this law. So we must be careful about how we draft this. Is this an act that you really want to put somebody in jail for? Do you think that it justifies this? There are some people out there who think any negative act towards any animal should put you in jail. But that's not really the social consensus. Then we have these various words that are used to bracket the word beat. Viciously beat, unjustified, or maybe torture. Everybody can agree that you shouldn't torture animals. I've never met a legislature who would disagree with that point. And in fact, torture is illegal almost everywhere under that word, torture. But what the word torture means is subjective to everybody in this room, right? Will we all draw the line in exactly the same place? I doubt it. But we're all against torture. But the law doesn't actually define what that word means. It leaves it up to others to determine what that means. Well, if you put it through the sieve, I think you're likely to come up with something like this. It's a misdemeanor. That's a lower level crime. For anyone to unnecessarily beat their dog, the dog of another. That has to beat your dog and the dog of another is an important construct because historically the law first made it illegal to do bad things to other animals owned by others because you were interfering with their property rights. It was a major breakthrough when, in 1867, Henry Bergh in New York got through the first law that covered first all animals, and secondarily, that meant that you owned or anybody else owned or was unowned. That was a long time ago, 1867. All right, so we've got that. And then we have proceeded to the point of defining the word beat. Beat is defined as the striking of a dog with an object that is sufficient force to break the skin or cause harm to the organ of a dog. You happy with that? Probably not. That sounds like that's pretty hard right there, right? But that's the trouble with defining the word beat. Do you want somebody to go to jail because they hit their dog? No. You know, where is it you want the government to interfere with what happens in your house? If you're conservative, you say they should stop at the door. They shouldn't be in our house at all, the government. If you're liberal, yeah, they're in the living room. Okay, so your philosophy about the role of government and individual acts will play a role in how you want to set out the law. How intrusive should the law be? There's also the very practical point of if you pass a law, it should be one that is enforceable. That's one of my little premises. It's silly to pass laws that you can't enforce. It diminishes the power of the law itself. So is this something that we could enforce? And if the law was you can't strike your dog, how are you ever going to know? The point of this definition is that one is serious because it has physical objective evidence that something bad happened, right? And a vet can say, yep, that's what it was. Not just secondary, well, I think he hit him kind of hard. What did he hit him with? I don't remember. Okay, so that's one reason why you might want to have that. Now, what's the other fudge word? Unnecessary. Thank you. Wow, how much is packed into that one word? Our whole culture is packed into that one word. How do you define what is unnecessary? Well, the law doesn't define that, and in almost no statute I know of on a worldwide basis is unnecessary defined, but it's in almost every law. And because that is the cultural construct of what is acceptable conduct. And so who does decide what's unnecessary? The jury. 6 people, 12 people, go to a room, have all the objective evidence of what happened, and they decide whether or not this is an unnecessary beating. Was he simply punishing the dog? Was he protecting the dog? Was he doing what was the construct around the act? This is the first law adopted in the United States that had the scope of what we're talking about today. This is just a portion, obviously, of the first section. It is illegal to torture, torment, deprive of necessary sustenance, or unnecessarily or cruelly beat or needlessly mutilate or kill any living creature. The truly breathtaking part of this was any living creature. No other law before this point had come even close to that. And they couldn't really mean it. This is 1867. Did they mean any living creature? Well, there was a case that dealt with large turtles, sea turtles, and the judge decided no, they weren't a living creature. So you can't apply it in the sense that we look at the phrase. It's if you go out and shoot a deer, what does that do here? So there are social constructs you must always have around these words to understand why they're there and what they might mean. And indeed, today's statutes, almost no statutes still have that phrase. Do you know what phrase they use to define which animals are covered by cruelty laws? Vertebrates. Which is rational in the sense that if you have a vertebrate, then you most likely do have the sensation of pain. And that is the primary initial focus of all cruelty laws. But if you don't have one, if you want to go out and beat a jellyfish, I don't know what that does to the jellyfish. And we don't either, and we're not going to spend our resources worrying about somebody. I mean, they may need psychological help, right? But I'm not sure that they should go to jail for it. Okay, so this is an example. Unnecessarily or cruelly beat. So there's 2 different adjectives that are around beat. And you see, this is lawyerese. I'm going to look at each one of them. There's an or, right? That means it's either unnecessarily or cruelly beat is what's illegal. And how would we distinguish between when is it unnecessary but not cruel, or cruel but not unnecessary? And I don't think there's too much difference there, actually. Because it's cruel because it's unnecessary. the law is aware of, the criminal law in particular, is to what degree do you want to get into the head of the actor and require the state to prove what were they thinking versus what did they do? Subjective, objective. It's much easier to deal with what they actually did than what they were thinking. I mean, there's obviously lots of people take President Trump. I can't figure out what he's thinking, right? I don't think anybody can. It's mysterious. So we have to be careful about that. And indeed, almost all the cruelty laws, but not all, don't require that we get into the person's head. They only require that we look at what happened. The other thing to keep in mind is that if you have a high degree of vagueness in the words, then there is the possibility of government abuse of that by selective enforcement. Well, it says you shouldn't do this, and you're my political opponent, and I'm going to use this as a ruse to get you, when I've never enforced it against any other person. In authoritarian states, this is what happens often. That China recently has taken the head of the International Criminal Investigation Unit into custody under potential vague terms, right? It's just a stunning example of how that can be. Now you could say, so we don't say with malice normally, although that was at one level, it was required that you would show malice. That means that the person had evil intent. The person had unacceptable motivations for what they were in fact doing. The other thing is to keep in mind two different levels of actions that we talk about, and one is negligence and the other is intentional. Negligence is, for example, if you're in your driveway, you're in your car, you put the car in reverse, and you run over a dog or a cat. You didn't know the dog or cat was there, you didn't mean to run over the dog or cat, but you didn't look, and that would be negligence. The opposite of that is when they see a dog in the road and aim for it with their car and run it over. That's intentional. And obviously intentional acts, and we would presume intentionality from, we didn't have to know what was in the person's head. Did the acts themselves tell us that that was intentional? They moved the car over and they aimed at and hit the particular animal. Okay? So we like to have that distinction made, and it's usually just intentional acts that are covered. Now the other thing is, we could pass a law that says it's a misdemeanor to shoot a cat with an arrow. Right? You probably all agree that's a bad idea. The problem, there's no problem with that, except that humans do so many bad things to so many animals in so many different ways you can't possibly list, right? All the bad things that humans might do to an animal. And that's why the cruelty laws are all compressed into a relatively short paragraph and use the word unnecessary as the adjective that limits the application of the law. We can't possibly list all the things that humans are capable of doing. I've been around the world a bit, and so I've picked up a few laws here to give you a taste of what things look like around the world. Here's a 2015 Spanish law, and their punishment will be imposed on anyone who, by means or procedures, unjustifiably mistreats, causing injuries which seriously affect the health or submit to sexual exploitation. That will leave sexual exploitation aside for today. Unjustifiably mistreats. Look at the word mistreats. I hate that. What does that mean? Mistreat. I mean, some people would think you mistreat your cat if you put him in a cage. The spectrum of mistreat is just not particularly focused, and so I don't like this law. It's got instead of unnecessary, it has unjustifiably. Same idea. British law. Unnecessary suffering. A person commits an offense if an act causes an animal to suffer, and the suffering is unnecessary. Okay. Have you ever had a discussion with somebody, a doctor, about what suffering means? They start to shake their head, right? And veterinarians talk about, I've asked a veterinarian, what about animal suffering? And they just say, I know what pain is. I can understand pain. Suffering is so vague that it's extremely difficult because it involves the psychology of the head and the mind. It's a physical act that causes a particular response within the mind. So I would never use suffering as my focal point for my whole law. So this is what the British have had. And the British have had this for 70 or 80 years. They've had this suffering as the key word. And the courts have talked about that in such a way as to make it rational for figuring out what to implement it. So within the UK, it's a doable thing only if you read about 10 cases where the judges explain what they think the word suffering means. And they're very rational what they do, I'm not saying that. But you can't go to, if you read that law, would you know what was illegal? No, I don't think you would. How about Ontario, huh? Oh my. No person shall cause an animal to be in distress. Really? If suffering is bad, what is distress? That's worse. They define it. Distress means the state of being in need of proper care, water, food, shelter, or being injured, sick, or in pain, or suffering, or being abused, or subject to undue or necessary hardship, or privation, or neglect. They've taken, this is a, they took about 15 sentences and made it all into one. That's very poor drafting. I'm sorry. I hope I don't offend anybody here. This is not the way you should write a law. There's so many uncertainties within this. And one big thing is they put both positive and negative things in here. The state of being in need of proper care. That is the duty that laws put upon somebody to say, if you're the owner, you have a duty of care. This is the scope of the duty of care. This is the outcome we want as a result of that duty of care. It should take at least a full paragraph just to cover that particular thing, right? But then they want to move on and being injured, sick or in pain, being injured. Well, okay, what injury? What does injury mean? What does sick mean? Comes down with the flu? Stub their toe? You're in violation of the law? You're going to go to jail? There's no constraints on the scope of what these words might mean. They're so vague. Is this cat suffering? Is this cat in distress? He'd like you to think that. I just haven't fed him. But he can look very mean when I haven't fed him. And what if I don't feed him for a day? Is that it? Should I go to jail? What level of insufficient care and food is it? Where do you draw the line and say, you go to jail? I don't think missing one day of food should put me in jail. I pay the price as it is with the cat. But enforceability. Go back to that Ontario one and think about, you're a policeman. How do you know when to enforce the law? I would suggest most policemen be clueless about when to enforce that law. Maybe agents of the Humane Society who have vast experience and knowledge about animals and what conditions they look to be in, and when you look at an animal, is it healthy? When you touch the animal, you can determine the condition of the animal, etc., etc. So we have 3 levels here of enforceability that you need to think about when you're drafting the law. Can a policeman determine when there's a crime? Will the state prosecutor be willing to file a case against the defendant? That's a very important second level, right? I mean, the policeman may say, yeah, I think something bad happened here, and they take it in, and the prosecutor then has to decide, can I convince, in their mind, that they have a construct, can I convince a jury beyond a reasonable doubt that there was a violation of this law with the evidence that the policeman has been able to put together? And for that reason, many of the things that you and I might think should be criminal acts, prosecutors are unwilling to spend their, first of all, it's just about animals, right? So how much time are they willing to give to an animal case? And secondarily, if it's, emotionally we can feel that, yes, it was a bad thing and something should happen, they're going to say, and thinking, can I get, if I have a jury of 12, can I get all 12 jurors to think beyond a reasonable doubt that a crime has been committed? And therefore, they only take the most extreme cases. When the horse falls over dead from starvation, they'll prosecute. But if a horse is underfed, are they going to prosecute? No, I don't think so. Then finally, will the judge take the case serious enough to impose any sanctions for the violation of the crime? Even assuming the jury agrees that there was a violation, then you get to the issue of sanctions. And we have found out in Michigan, we're right now talking about the fact that under our sentencing guidelines in the state of Michigan, unless you are previously guilty of a felony, the first time you violate the animal cruelty law, it's a total slap on the wrist. 30 days suspended sentence might be something that would happen. But otherwise, the sentencing provisions and the judges just don't take animal law all that seriously. And the people, I know there's many good willing people that think the answer is to increase the punishment in the statutes. So for dogfighting, we went from a 1-year felony to a 6-year felony. It's irrelevant, because that doesn't really impact how sentencing occurs in the courtroom. And until you really understand that and witness that, then you don't quite understand what's necessary. And what's necessary is a social shift within the judiciary of your country to accept and raise up the priority of animal protection as a social concern of that country. I watched this happen for environmental law, very specifically. In the 1970s, when cases were brought, particularly wetland protection cases, they'd say, no, there's no social good in protecting wetlands, and therefore we're not going to find that there was a violation, or the state's trying to regulate it has to be set aside because it's not justifiable interference with private property rights. 10 years later, the states were saying, the courts were saying, yeah, this is pretty serious stuff. Actually, wetlands are an environment of social concern, of environmental concern, and therefore also of social concern. The importance of the environment enhanced and changed the judge's view of the same set of facts. And now, I'm familiar with cases that involve trade in endangered species, for example. And whereas before it was a slap on the wrist in the United States, it's now felony time. I mean, you will go to federal prison if you are a commercial trader in a listed endangered species. That's not happening in Africa. It's not happening in Asia. The enforcement level is not happening because they don't care yet about animals the way we do in the United States. So part of your law context is understanding and promoting the increasing importance of animal issues within those who are the decision makers in the legal institutions, be they legislators, prosecutors, or judges. Okay? All of those groups have to go with society up the stream of concern, or it's not going to be work. The laws aren't going to work. Who decides if a particular act is a crime? Okay? Obviously, the legislature can do it. It's a crime to strike a dog with an object weighing more than 10 pounds, kilos. Okay, that's a specific act. If you do that act, the legislature's decided you go through the process. Or if the crime is stated as unnecessarily beat a dog, then the decider is either the judge or the jury. The legislature has delegated that decision to the court. Right? Said, we can't cover all the fact patterns, we're going to leave this up to the court. A third thing that can happen is that the legislature can delegate to an agency. All right? And the agency will adopt regulations further defining what is legal and illegal. That also brings up two things to think about when you're drafting law or thinking about law is the easiest thing to do is to have a law that is a straight prohibition. Thou shalt not X. Clear. But, in other words, we could just say, you cannot have any chickens in a cage. Period. Then you walk into a farm, if they're in a cage, it's illegal. But if the legislature is not willing to do that, they may say, we're going to turn this over to the Department of Agriculture to determine what's an appropriate cage size for chickens. That's the regulatory process. They've delegated the determination of what's unnecessary to the agency. And in theory, the agency is supposed to help use science to decide what to do. Is it necessary to kill that dog to protect a child? If it is, then you can kill the dog. Right? No law says that, but it's inherent in our entire criminal system that protection of self and protection of another justifies violence against both other humans and other animals. What's not clear is protection of your cat. The dog starts to attack your cat, can you shoot the dog? That's not clear. In fact, I'm not sure what that is. Tail docking. Pretty good example. A number of jurisdictions in the United States have simply said, nope, can't do it. We don't find any socially justifiable reason to cut off the tail of a dog. Therefore, it's a prohibition. No tail docking. Unless a vet has it, whatever. But not all states have done that. Chickens. Cageless, cages. The national U.S. law is an embarrassment. I understand you also have some difficulties with your national law too, so I don't feel too bad, but ours simply cuts out by definition of the word animal all farm animals. So the U.S. Animal Welfare Act doesn't include the category that is most dominant. And this was written a long time ago, 30, 40 years ago, so it doesn't reflect how we might draft things today, but sometimes when it gets in the law, it's really hard to get out. And this says everything is delegated to the Secretary of Agriculture, and it says it'll develop standards to govern the humane handling, care, treatment. And that's the only criteria given to the agency is the word humane. Oh boy, what does that mean? What does humane? Well, it depends on if you're a pig farmer or somebody in this room, right? Pig farmers will tell you how humane their actions are in the context of commercial farming. I'm the best commercial farmer around. I care the most about my pigs, but they're still in those limited facilities. And we had a case, the state of New Jersey passed a law somewhat like that, but it did deal with farm animals, requiring an agency to come up with what the word humane meant. And it was a mess. For an agency, they made a fairly good attempt to do the right thing, but somehow it turned out that just about everything agriculture was doing was acceptable. Then we took it to court. Various organizations, I wasn't actually an attorney on that, and said to the judge, the law says humane, and look at these particular specific regulations that they wrote, these aren't humane. And then you come to the sad point that almost, I'm sure in Canada, I know in the U.S., A judge gives deference, the word is deference, to an agency because they are perceived to have the expertise necessary to draft these laws. And therefore, the burden is on the plaintiff who's complaining that they must prove that X went too far. And if it's questionable in one way or the other, then the agency gets to have its decision stand. And that makes it very hard. And in the case, some things were cut out, but the vast majority of the regulations were kept in place. How might you all think about this? This group is already engaged in animal issues, I know, and therefore you're well ahead of most members of the public. But here's a rough roadmap to moving forward, if you would. Is there social consensus that a particular problem needs to be addressed? Let me give you an example of one that I did not think was ready to be addressed. I had somebody email me. I get all sorts of emails, you can imagine. And this guy said, I'm really concerned about those walkways and airports that are you get on and it just goes forward and then you get off at a certain distance later. Because his dog was walking on it and his dog did something weird and he got his paw caught at the end of those walkways. And he said, we should make it require everybody, they should have guards on every point to remind people when they step off to protect themselves. And I just had to say, I'm sorry. I don't think that rises to the point of the law requiring every airport to post somebody at the end of a walkway just to remind you about the fact that there's a danger at the end of the walkway. So that one we set aside. The other thing is if you have something you're particularly concerned about, talk to a lawyer. They're helpful sometimes. Have a clear statement of the problem and possible solutions. Take it to decision makers, be it an agency or the legislature itself, and see if you can motivate the legislator to deal with that particular issue. And the art, and it is an art of lobbying, right? This is not something everybody actually can do. Sometimes people don't know how you go about this. It's a human dynamic, right? And if they're not worried about the ethics, then maybe you can make an economic decision. Maybe you can find positive things to do for it. In other words, do something else for the legislator, get votes for the legislator in response to helping you with this. Make it a PR event. Become politically active. Write a check. The animal movement's been pretty unsuccessful in the political contribution arena of getting legislators on board by writing campaign contributions. So we can't write a check with enough zeros on it to make any difference. But if there's somebody who can write a check with a lot of zeros on it, think about political contributions. So I want to thank you for your attention today, and I'll be happy to take any questions you might have about, is there anything that deals with animal law?